Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about spousal support. Cases that should have gone to the Supreme Court of Canada, but didn't. When you marry a person, you don't just marry the person they are the day you marry them. The whole point of marriage is that you're committed to this person for the rest of your life. And yes, lots of marriages don't work out. But the idea is that you're going to be with that person through thick and through thin, the good, the bad, the ugly, all of that. And that means that when you marry somebody who has a potential to earn a lot more money that isn't realized until after divorce, there may be some entitlement to greater amounts of spousal support on the basis of the increase in the income after the divorce. If you marry somebody and contribute to their progress in their career, but the marriage ends before they reach their peak level, but they got there as a result, sometimes, of the support and network that you provided as their spouse, and you, as somebody who was married to them, was expecting to achieve that end goal with that person before the collapse of the marriage, should your spousal support entitlement not rise with the increase in income that your ex-spouse has? This was the case that the Supreme Court of Canada had to consider and refused to consider, involving a married couple who had exactly these circumstances. And unfortunately, this leads to an important issue for people, which is the timing of their divorce and the terms of their separation now have to take into consideration not just their current circumstances and obligations to their children and pets and things like that. It also has to take into consideration, for people who are seeking support, the potential that somebody might earn more money in the future. And separation agreements have to be drafted very carefully to allow people who want to take advantage of those opportunities to ask for more spousal support if their ex-spouse's income goes up in the future. This places a greater burden on litigants at the litigation stage, and it also creates difficult evidentiary burdens should these matters proceed to trial. How do you prove what somebody might earn in the future as opposed to what they're currently earning? And how do judges sort through these issues? The Supreme Court of Canada had the opportunity to provide some guidance on that, to streamline this process, to educate lawyers and people involved in divorce settlements about what they need to do and what they need to consider. And instead, they kind of just left the door open, which is only going to cause more of a burden on the courts and more of a burden on lawyers and the justice system as a whole as these things get sorted out. And that's not something that we want to see. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.